Good morning, or in the case of our European friends, good afternoon, and possibly for some of you, good evening. And welcome to this ACT, Autonomy Through Cyberjustice Technologies meeting. This workshop, as you all know, aims to discuss the impact of the use of nudges on legal decision support online tools as well as ODR platforms. So my name is Nicolas Vermeys. For those of you whom I haven't had the pleasure of meeting, I'm the Associate Director of the Cyberjustice Laboratory. My friend and colleague Valentin Calipel is going to help me host this meeting, this workshop, but obviously this is a discussion, so hopefully everybody that is present will take part. You've received the agenda, so I don't want to spend too much time on it. We'll start with a short presentation by Sylvain Longhais, an ACT student who has been working on and studying nudges. So he will give us a brief overview simply to make sure that we're all at least on a level playing field. I know that some of you are experts in the field. I see that Ayelet Sela is with us, who obviously could teach most of us a lot about nudges, but to make sure that we all have at least a minimum understanding of what we're talking about, Sylvain will give the opening presentation. And then we'll have three colleagues present some platforms that were developed in the field of cyber justice and answering a few questions that were submitted to them beforehand on how nudges are impacting these platforms. So I would just like to welcome Richard Rogers from the Civil Resolution Tribunal and thank him, because for Richard, I'm thinking it's something like 6 o'clock in the morning right now. So we're always happy to have Richard with us, and specifically happy and thankful that he accepted our invitation, considering how early this is for him. And then we'll have Anais Westermann, who's, who's also a student working for the ACT project, and Anais is doing his PhD thesis under the guidance of ACT Director Karim Beniclef, who is with us and whom I would like to welcome. And so Anais will present a project that we're working on called the Justice Bot. And last but certainly not least, our colleague Ken Satoh, who will present a project that he is developing and that I can't wait to hear about, a system to arrange issues in civil litigation. So on that note, I will cede the floor to Sylvain for the initial presentation. I hope we'll have very fruitful discussions. And so Sylvain, the floor is yours.
Good morning and afternoon, everyone. I am Sylvain Longhais, research assistant at the Cyberjustice Laboratory, and I'm very pleased to present this short introduction to the concept of nudge as part of this today's workshop. I hope this presentation will help you to familiarize with this notion as well as its implication in a digital context and is in a cyberjustice context. In order to have the best understanding of nudges, we will divide this presentation in three parts. So firstly, we will generally discuss the notion of nudge and develop some aspects about it. And secondly, we'll put nudges in the digital context. And thirdly, from this digital context, we will see how nudges can be implemented in the cyber justice context. Well, we're not going to spend much time on years of doctrinal developments and quarrels between different economic schools of thought that led to conceptualize nudges. For the purpose of our presentation, we need to know that two American scholars, Richard Thaler and Cass Sunstein, released in 2008 a book called Nudge: Improving Decisions About Health, Wealth, and Happiness. Their work has been greatly influenced by behavioral psychology studies, and more precisely studies about individual decision-making process. But these authors are not the only ones that have gained interest in behavioral psychology, and many economists got interested in this question, and it progressively became a full discipline called behavioral economics. The school of thought generally contrasts with the rational actor model, the main model used in neoclassical economics. And the authors, Thaler and Sunstein, criticize the rational actor model and its flaws, the lack of realism mainly, and the fact that this model is only useful to theorize a macroeconomic environment. So behavioral psychology in economics is mainly developed in the light of economic aspects, and nudges ensue from this school of thought. Therefore, we should be careful on the application of concept of nudge in other disciplines. And now we have some elements of background. We'll talk about nudges and as what they precisely are. So the book Nudge is actually the starting point of such a generalized craze for nudges. In the book, the word nudge is defined this way. Nudges refer to any aspect of the choice architecture that alters individuals' behavior in a predictable way without forbidding any option or significantly changing their economic incentives. So with mechanisms affecting choice architecture, the purpose of nudges is to foresee how an individual would react in one or another situation, and therefore to encourage them to follow the direction we want them to go, but without ever forbidding any options. In other words, a nudge is divided in two parts, encouraging a certain behavior and preserving the freedom of choosing any other behavior. Then, this is not surprising that when the book was released, many governments developed an interest in nudges and even put task forces together in order to study nudges implementation as a regulation tool, for instance, in the US and in the UK. By the way, the main argument in the book was that with nudges, government could help individuals to make better decisions without restricting their freedom of choice. And this precisely pictures the philosophy behind nudges, libertarian paternalism. So what is it? In fact, this is merely merging these two elements, encouraging a behavior for the good of the individual while preserving the freedom of choice. Let us try out a practical example. Organ donation. So a nudge could consist in placing by default people on the list of organ donors. So by default, people would give their organs when they die, but anyone could opt out of this list at any time. So we encourage a behavior, but the freedom of choice is still preserved. Now we have basis for nudges, but we still lack practical examples on how to materialize them, and this is what we'll see now. So nudges go together with cognitive biases. Any nudge aims to modify the choice architecture by exploiting a cognitive bias related to a system of thinking. We traditionally make a distinction between two systems of thinking. A system one that works automatically, unwittingly, and intuitively, fastly, and that does not need a lot of effort. In general, system one is the reasoning system used by default because it needs less energy. So the system one is also at the origin of creativity because intuitive associations it makes. And then there is a system two. This system is mostly and sometimes wrongfully associated with the faculty of thinking. It requires concentration and intention from the individual. It intervenes in the resolution of complex problems with an analytic approach. However, it is slower than the system one and take over system one when the latter faces a problem it cannot solve. So for instance, it is because of system two that an individual is able to fill a tax reporting. And cognitive biases can occur from both of these systems in different ways. But what is a cognitive bias? So there are forms of thinking that deviate from rational or logical thinking and that tend to be systematically used in diverse situations. Now I'll give three of the most frequent cognitive biases, and we will see how to nudge an individual to the decision we want them to make from such a bias. So first, the framing bias. It means that our decisions are influenced by the way the information is presented to us. Here is an example that is particularly relevant in this period of COVID. So let's say we can choose between two hydroalcoholic solutions. These are the exact same, absolutely no difference with the same price, but one solution brags about killing 99% of germs, And the other one boasts about the fact it only lets 1% of germs alive. And we would tend to choose the one killing 99% of germs because the second actually insists on the fact that germs are still living. Therefore, the way the information is presented appears to be crucial. A second bias is the statistical bias. In behavioral psychology, we realize that an individual would naturally tend to stay in a situation by default rather than changing it. Remember, for example, the organ donation list. So let's say I'm selling cell phones and I would rather sell one product with a specific configuration because this is the one I'll make the biggest profits with. So by default, I would display on my website the model with this specific configuration. The buyer would therefore tend to buy this product rather than changing for another one, even though the other one would suit their needs better. Here, our example is illustrated with the Samsung model that is displayed by default. Thirdly, the social norms bias. Here, we will use the group effect and make emerge different norms and standards of this group. These norms and standards will induce a certain social behavior. So we all know this, the following example. So let's say I'm a big tech firm that initially specialized in online bookstores and progressively extended my worldwide empire to e-commerce in general. So I sell a product. To encourage people to buy an additional product, I will indicate that 98% of people that bought this initial product also bought this specific additional item. This would potentially trigger the purchase of this additional item. Now, how to concretely use nudges in a digital context. We've seen some examples. Now we're going to see some tools. Digital nudging is defined as the use of user interface design elements to guide people's behavior in a digital choice environment by adjusting visual attributes and deliberately presenting choices or organizing workflows. So in fact, it is modifying either the choice content, put in other words, the displayed options, either the way how options are displayed. Therefore, digital nudging is a powerful weapon because the decision-making is directly linked with the choice environment and then with the choice architecture. But it is also formidable because nudges are easier, faster, and cheaper to set up in a digital context. To set up digital nudge, we generally use all these tools. So drop menus, radio buttons, checkboxes, sliders, pop-up windows, but widely all the tools from user experience design. For instance, I could also use a drop menu that is visible in order to encourage the user to use it. In the end, it depends what purpose is decided before, and this is why setting a purpose prior integrating a nudge is really important. Now that we have a global insight of what is a nudge and its digital context, we will see its application in cyberjustice. So nudges in cyberjustice, we selected like a couple of questions. So why integrating nudges in cyberjustice? What do we need to do that? What are the limits of nudges in cyberjustice? And what are or what could be the good practice in integrating nudges? So first of all, why? A choice architecture is never neutral. Minor changes can result in encouraging one or another behavior. We've seen that neutrality in choice architecture exists even less in a digital context. So when it comes to an online dispute resolution platform, for instance, we can use nudges to counter deleterious effects that are inherent to the user interface, but that could harm values of judiciary system. Therefore, it is about to counter with nudges the alteration of decision-making process that is induced by the technological architecture itself. This is the idea that the platform becomes an additional party to the proceedings. Therefore, we need to take it into account and keep in mind that this is not neutral. And to counter this alteration in decision-making, we could help users to maintain the freest and the most informed decision-making as possible. But integrating nudges in cyberjustice, it is also increasing the access to justice, serving the interests of all parties in the dispute, and it is also participating to a choice environment that sticks to values and functioning of courts while gaining effectiveness, provided that we firstly define what effectiveness is and for what. What do we need to implement nudges in cyberjustice? So optimizing the system will go through a study of what we want to improve in the process. Do we want to improve the celebrity of the process, the neutrality? It also should be kept in mind that any nudge could improve a desired result at the expense of another desired result. Therefore, it is necessary to identify needs of different parties prior to optimization action. In the same way, we could encourage a behavior for one or another purpose while exposing to other risks. So it is always, in the end, a balance between benefits and risks. But more than just actions, the tools we want to use should also be identified. And generally, in ODR platform, for example, we will find radio buttons, checkboxes, text boxes in order to encourage users to choose one option rather than another. Each button should take advantage of cognitive bias. Therefore, the cognitive bias to leverage should also be identified prior to set up such a tool. In the same way, it would be useful to wonder at what stage of the process nudge implementation is the most relevant. Another thing is, it is important to identify the interests of parties to be nudged. That could be useful to precise the nature of nudges that we would implement and therefore avoid deleterious effects. So 2 types of interests, the collective interest first. For instance, in a platform architecture, we will implement nudges encouraging the plaintiff to settle amicably a claim if we consider that the interest of both plaintiff and respondent is to settle the dispute by negotiating. And then an individual interest. A good example of individual interest is the self-represented litigant that ILSL develops in our article, E-Nudging Justice, the Role of Choice Architecture in online courts. In this case, nudges could help to better understand certain displayed options in order to make better decisions. And both collective and individual interests could converge at some point. But we should always keep in mind that the application of nudges in cyberjustice is not an exact science. It is still purely experimental. So the first limit is the counterproductive effect. There is an example which is outside of the cyberjustice context, but in which nudges had a counterproductive effect. For instance, a nudge that was once implemented in order to increase feedback numbers, but that turned out to be the reason why people were leaving a website. And also the ethic of nudge should be questioned. For instance, what is the real degree of freedom of choice infringement? Therefore, good practice guidelines could be useful when it comes to integrate nudges. It is even more important in cyberjustice. Some guidelines have already been established in digital nudging. They could be a good starting point for nudges in cyberjustice. So in this example, we have 3 criteria for the nudge: transparency, high degree of resistance, and absence of control. We would apply these 3 criteria to any nudge depending what system of thinking it affects. Then we proceed to the evaluation of the digital nudge regarding the pre-established purpose. So in conclusion, implementing nudges in cyberjustice is possible, even though some questions and observations should be taken into account. This is the reason why, from the observations we made, we raised a list of 10 points to focus on when it comes to integrate nudges in cyberjustice. So access to platform, registration on the platform, materialization of consent to participate in the process, explanation of the procedure before starting the process, access to legal information, simplifying the filing and review of documents, as well the level of accessibility on the platform, the correct information of any new event on the platform, the confirmation of that an action has been actually carried out, and of course the preservation of the autonomy, freedom of choice of the litigant during the process. And this list constitutes the starting point of this workshop. So I'd like to thank you very much for your attention, and I wish you all a good workshop.
Well, thank you very much, Sylvain, for that comprehensive explanation of what nudges are. And I'm sure that we'll be able, during this workshop, to delve into some of the issues that you mentioned. And so getting back to these 10 questions or 10 vigilance points that Sylvain just presented to us, these are the same 10 points, obviously, that were sent to our 3 presenters to start the discussions going. So without further ado, I will cede the floor to the first presenter. As I mentioned, the first platform will be that of the Civil Resolution Tribunal, which many of us at this point are very familiar with, it being a precursor in the use of cyber justice platforms for the courts here in Canada and in fact around the world. And presenting this platform will be our friend and colleague, Richard Rogers, who is a registrar and the executive director of the CRT.
So thank you again. I apologize because I have not framed these specifically in the context of the questions because we're rebels out here in British Columbia, so didn't want to comply with the request at all. But I have gone through and taken some screenshots of our system and our platforms and the user interfaces that do hopefully lead you to the answers of some of those questions, although not specifically. So just by way of background, the Civil Resolution Tribunal here in British Columbia provides end-to-end dispute resolution services in the areas of small claims up to $5,000, strata or condominium disputes, essentially governance disputes at condominium buildings, as well as societies and cooperative associations, and excuse me, accident benefit disputes currently with our government Crown motor vehicle insurance provider. And up until Tuesday of last week, we did also have jurisdiction over some automobile personal injury cases as well. But as a result of a decision on constitutionality, we don't have that currently, but the decision is under appeal. So this slide just sets out our dispute resolution process that obviously to get started, you get information about your dispute, and we have an expert system, the Solution Explorer, that helps people with that, gives them information about their dispute area and tips and tools that help them try and resolve it themselves. If you can't do it at that stage, then you can apply online to the CRT for a formal dispute resolution process. We'll process your application and notify the other parties to the dispute. At that point, if they respond, we put the parties into an online negotiation platform. And if they don't resolve it there on their own, we assign a staff case manager to facilitate an agreement discussion between them. And if it's not resolved at that point, then they go through an online adjudication process where they provide their evidence and submissions and get a decision from an independent CRT member. So the CRT platforms, there are 2 of them, were designed now about 6 or 7 years ago, prior to our launching in 2016. And at that time, they were not designed explicitly with nudge theory in mind. It was done with a user experience approach, which certainly incorporates some aspects of nudge theory, and with our own sort of practical thoughts on what the system should look like. We didn't have a whole lot of templates out there to go by. This last summer, we did have a combined user experience and behavioral analysis done on our overall system, and currently we're working on a major review and rewrite of the overall platform, the online dispute resolution platform. But our philosophy is generally that we don't want parties to have to go into the process by reading and understanding all our rules and our legislation. So we want the platforms to provide that information to them, but also provide it to them at the point they need it. So not providing them with everything at once, just on a spoon-fed basis. Almost all of our material is targeted at a grade 6 reading level, and it does encourage the parties to self-manage their dispute, but we do make human support available to them when they do need it. So we, and also admit that didn't really think about nudges in the context of our platform too much until being assigned or asked to do this presentation. So I went through the overall platform, and you realize how many places there are actually aspects of nudge built into it. But overall, what we do want the parties to do is understand their obligations through the process. So there are aspects of the platform that have that philosophy built into it. So we want them to participate in the facilitated discussions. We don't necessarily force them into an agreement, of course, but we want them to participate in those discussions in good faith. We also want them to provide the information that they should provide at the various points in the process, including evidence to support their position, arguments to support the position, and so forth. We also want parties to know where they're at in the process at any point in time. So we will provide wayfinders, we'll provide communications to them to say, at this point, you're going into negotiation. Right now, you're going into facilitation, and we're going to assign a case manager to try and help you resolve your dispute. We also want them to know what deadlines apply and what specific requirements they have on them at that point in time. One of the primary objectives of our nudges is actually somewhat selfish in that we want our resources to be used efficiently. So although we want to provide support to the parties and help them with their user experience, part of our motivation is that we want them to provide the information on the first time through the platform and avoid unnecessary requests from our staff for them to provide that information or clarify it. We also want to encourage and direct them to our online platforms, because we do offer dispute resolution services on paper, by mail, and certainly to a certain extent by telephone. So we try to drive them to our online tools. The primary driver of that is that it's available 24/7, and they can use it at their convenience wherever they are. Note that most of the actions through our online dispute resolution platform are done through a secure CRT account that they set up at the start of the application process. And so this screen just shows our dispute resolution process again, but in terms of the systems that support them. I mentioned that in the first step, where they're diagnosing their issue, getting information about it, and trying to resolve it themselves, they use the Solution Explorer. At intake, they make an application, we screen it, we notify them of the results of that screening, and we provide the other party with notice of the dispute resolution process. The other party responds, or it goes to a default process. And at that point, they're using our dispute resolution suite platform through their CRT account. And we put them then into the party-to-party negotiation. There's no staff involvement in there generally. And if, as I mentioned, if they don't resolve it there, they move into the facilitation, which is done both through the platform, excuse me, but also through email and telephone. So it's not all done on the online platform. They next go into the adjudication stage if they need it. Most of the preparation for adjudication is done through the platform, and the vast majority of our disputes are resolved that way. There are some where we may, outside the platform, request additional information or clarification of issues, and in very rare cases, we may hold an oral hearing component through the use of an online platform or telephone, or in extremely rare cases, through an in-person hearing. So the Solution Explorer has a number of nudges built into it. The first one, of course, is to provide people with legal information they need so that they can understand their dispute, and so they can understand what their likelihood of success given their circumstances are. We also want to nudge them towards resolution without the CRT having to get involved. So it provides some practical self-help options and tools. The most common of those is a letter template, a demand letter template in the context of condominiums, a request to their strata corporation to consider their request. And this screenshot just shows an example of the starting point of a demand letter where it provides the template to them and instructs them which fields they have to complete to prepare that demand letter. If they don't resolve it through the Solution Explorer, as I mentioned, they move to our online dispute resolution platform, Dispute Resolution Suite, or DRS. We provide them with a checklist, as you can see from this screenshot, giving them an idea of what information they need to complete the application, as well as external links about the CRT process, how it works, and then additional resources that may help them understand some of the legal background to their claim, including information sheets on limitation periods, those sorts of things. We also explicitly ask them to acknowledge that they understand the information they provide to us will, for the most part, be shared with the other parties. And I'll note that when we first developed the platform, that was not there, and it became quickly clear when we got complaints that we were sharing people's or notifying the other party of the people's application, that this was a critical requirement. We also have some financial incentives built into our tools. The most clear example of that is that we provide a $25 discount to applicants if they apply online. There's also discounts on some of our other transactions. And at this point, we're getting at least 98% of our participants do everything online and get those discounts. But we do, as I mentioned, offer the choice of applying by mail, email, or fax through paper forms or PDF forms. We also mentioned that we do screening of the application when we receive it. We have to make sure that the CRT has jurisdiction over the claim as stated by the parties. So where we do initially find problems with jurisdiction, we'll go back to the party, provide them with an initial assessment that the CRT does not have jurisdiction, but then give them two choices. They can accept that assessment, and we will provide them with a rationale for the assessment, as well as, if appropriate, links to other bodies that may have jurisdiction over the matter. And the party can accept that and get a refund of their application fee, or they can make submissions on the jurisdiction issue and proceed to have that considered by a tribunal member. At that point, they don't get their application fee recovered. We also have a nudge that I would describe as avoiding a deterrent to participation. So it's promoting access to justice. So for participants who cannot afford the CRT application fees, we have a very easy and quick fee waiver process that is done entirely online and does not require them to provide documentation to support their financial information in most cases, unless we do an audit and request it later. And so this is another screenshot that shows the online fee waiver request that's fairly simple. For example, if they're on income assistance or welfare or some of the other income support programs, they click yes to that. They confirm at the bottom that they're providing accurate information, and it's automatically approved for them. Otherwise, they provide their household income, the number of people in the household, and we have some fairly generous fee waiver financial criteria that is based on Statistics Canada's low income measures. We also promote settlement for the respondents during the response cycle. And so this is a screenshot from the response form, the online response form. So we ask them to describe what they've done to resolve it so far, which may or may not be anything. And we also ask them, is there anything that they're willing to offer to resolve this? If they provide some information there, it isn't automatically provided to the other party, but it will go to one of our case managers who will then see that there is a basis for discussing resolution with the parties, or at least a starting point. The other purpose of these questions are to at least put it in the mind of the respondent that they may want to think about some sort of consensual resolution. As I mentioned, after the intake process, they go to the party-to-party negotiation platform. And at that point, we do advise the parties that if they settle during this stage, we will refund their application fee. And so this is obviously primarily a motivator for the applicant who has paid that fee, but more sophisticated respondents will understand that there is some benefit to them of reaching a settlement at this point, because they could then avoid potentially successful claim for those fees that they may then have to pay back to the applicant through a cost order. During our facilitation stage, which is supported by our staff case managers with mediation training, this is mandatory, so the party's consent isn't required, but the case managers, through their communications and discussions with the parties, will focus on encouraging the both parties to engage in meaningful participation in the process. So even though they may come into it somewhat resistant, they will try to overcome any of the reluctance the parties may have to discussing settlement. As well, during that facilitation process, there is statutory authorization for our case managers to provide a non-binding neutral evaluation. So this may also provide some parties with motivation to work towards a consensual resolution, depending on what that evaluation is. And of course, we use that fairly carefully, that we don't want to apply it in every case, and only where the case manager is somewhat certain of what the evaluation should be. During our adjudication preparation stage, where we're collecting evidence and submissions from the parties, the primary purpose of our nudges are to encourage compliance with our rules. For example, we have limits on the number of characters they can include in their submissions or arguments portion. We also want to make sure that they're very clear about what deadlines apply to them in submitting their evidence and their arguments, and we provide reminders of those deadlines to them so that they understand the consequences if they do not comply. And there's also system supports to the parties to help them both uploading their evidence and making their submissions, including in application information about what they're supposed to be doing and what the deadlines are. And also we will provide instructions at the time of application. And we also do include in most of our platform some contact information, our ability to contact the CRT and get personal help if they need it. But again, we want to encourage people to use the platform as much as possible, but there is help there when they do need it. So this is just a screenshot showing the instructions to a party at the start of the evidence gathering process. And you'll see that there's very clearly a button that they click at the bottom of this information that takes them directly to the screen for uploading evidence to the platform. As well, each area of the information, this one's a little longer than we would like, but this is the start of the adjudication process, so fairly important that they have all the information they need, but there's clear headings so they know what that paragraph is telling them about, what the reason is for the message, what they have to do, and then what the deadline is. And similarly, this is instructions that the parties will receive for uploading their arguments. And again, clear subject lines, as well as a link to add their arguments directly in the platform. And these will be messages that they will either get by email or through the platform itself, or in some cases through both. And again, just mentioning that the deadlines in the platform are very clear to the parties, and in this case, it's provided in 2 places to make it clear that they have to provide their submissions by April 11th. And so there's no way that they could subsequently say they weren't aware of the deadline, but also to make it clear that this is important. So happy to discuss and answer any questions in the context of what was in the overview to this session. Otherwise, here's the contact information for both me and the CRT. And I did want to acknowledge Lauren Kerr, who I don't think has joined us this morning, but she was somewhat instrumental in providing some content suggestions for this, excuse me, PowerPoint presentation.
Well, thank you very much, Richard, for this extremely useful presentation and very interesting presentation of what nudges are incorporated in the CRT platform. And I don't know that you're as much of a rebel as you claim to be, because clearly looking at the points that we were asking you to cover, I believe you covered most of them. So thank you very much for all of this. We're now going to listen to our second presentation, which will be given by Anais Westermann, who is a PhD candidate at the University of Montreal Faculty of Law. And so Anais will present the JusticeBot platform that is being developed right now at the Cyberjustice Laboratory.
Great. So my name is Hannes Westermann. I'm doing my PhD at Université Montréal with Karim as supervisor, and also work on the Justice Part project at the Cyberjustice Laboratory. And I'll be presenting today together with Mark Likhten, who's also on the team, nudges in the Justice Part project. So the way we'll go about this is to briefly present the background of the project, what we're aiming to achieve with it, and then show you the current state of the project. You might be familiar with the project, but we just want to show you what we've been up to and how the current iteration of the user interface looks. Then we want to discuss some nudges, just as a starting point to think about some of the potential nudges we see in this platform, and then wrap up with a brief conclusion. And then we're, of course, super interested to see what other potential nudges you see in the system and how to deal with them. But let's start with the background. So, well, the background is that laymen often seem to have trouble resolving everyday legal issues. And that is legal issues with a low intensity but high volume. That is, there's many of them, but the monetary value isn't that large. So two potential reasons for this difficulty is that the law can be very complex. It's difficult to understand for laymen and to deal with. And that courts can be quite expensive when dealing with cases like this. And this can be in terms of monetary costs, since lawyers are quite expensive to hire, especially when the contested value is not that large. But it can also be about time. These issues can take up to several months, or in terms of emotions, it can be a very frustrating experience for a person who is not really involved in the system to go in front of court. And so the area we're focusing on here is landlord-tenant disputes. And there's an area where these kind of decisions are quite common. So the Tribunal Administratif de Logement of Quebec deals with about 70,000 such cases per year, and it can take several months to resolve cases. So we want to ask ourselves, is there a better way to do it? And our answer to that is to look at the Justice Part project. So the idea is that people would be able to enter a kind of chatbot that would ask them questions about their case and then provide them with relevant information to make the people more informed. And so we're working at the moment, we're very lucky to be working with the Tribunal Administratif de Logement and Université de Montréal to build this platform. So you'll see now a prototype of this, but we're looking to launch this quite soon. So this is what a person would see when entering the Justice Part. First, there's an introduction that explains in easy language what will happen. So it explains how the system works and what to expect. So the system you see here is in French, since that is the language of most of the cases here, but we're looking to make this bilingual eventually. It also says what you can expect and some more relevant background information. It also says what you shouldn't expect. So it makes it quite clear already at the beginning that this legal information, and people should always consult with a lawyer before taking any decisions. And we'll get back to that as well. But so then the people can navigate the system by selecting the appropriate response. So here the answer is, I understand, just to explain that they've read this information. But then the system will try to triage their legal issue by looking at these responses. So the first question here is, are you a landlord or a tenant? And there's, as you can see here, there's a simplified explanation of what these terms mean to the user. So let's say in this instance, we're a landlord. And now we're presented with a menu of issues that the Justice Part can deal with. Again, they're easy language, and they're kind of describing a potential problem or situation that the person faces. For example, the tenant wants to leave their apartment before the end of the lease. They have already left, or perhaps they've stopped paying. So let's go with that one for now. So next we'll see a number of questions that try to further understand the situation of the user to be able to provide information. So the first question is the tenant currently late with the payment of their rent? Again, there's some relevant information here, simplified, and also reference to to the law if you want to go further to understand this issue. And what you'll see here now is examples of decisions. And this is one of the key components of the Justice Part. That is, people are always given the possibility of seeing decisions that can help them understand how this issue will potentially be dealt with, if they should go to court. So we have examples for yes here, but also examples for no. And clicking at these, we will see, we can go to the case to read the case, but also see a short summary to better understand what elements the judge will look at in applying this question. Let's say in this instance, yes, that the tenant is late, but they're not currently 3 weeks late. So there's another question here with some information. You can expand it to see more. This question is the tenant often late with their rent? And I think this question kind of highlights one of the key advantages here, because often isn't really defined anywhere. It doesn't say in the law what often refers to. So we give some information here, but here's, I think, where the case law really becomes important. Because by looking at these examples, the person might be able to determine for themselves what their situation most closely relates to. So looking at the cases here, for example, there's an example of a case where the tenant paid their rent 5 times late in the past 8 months. And there the judge considered this to be frequent lateness of payment. So let's say yes in this case. And let's also say that there was a serious prejudice caused by this repeated lateness of payment. What will happen now is that the system will analyze the responses that we gave and look for relevant case law. And at the end, we will receive a list of information. So these are kind of information blocks that have been selected based on the answers that we gave. So we said before that the tenant is currently late with paying their rent. And this information here, that a potential consequence of this is that you might be able to ask back the rent from the tenant. And again, there's examples of decisions where this particular criteria was applied and examples of what outcome was awarded there. We also said that the tenant was frequently late with paying their rent and that this caused a serious prejudice. Again, we're saying here that the potential consequence of this is the termination of the lease. So by looking at these, the tenant can kind of understand potentially what could occur in their case. You can then go on and here receive information on what they could do next steps. So for example, they could receive more information online. They could try to use this information to go to their counterparty and see if they can come to a friendly agreement. They could also obtain further counsel or go to the court. And finally, of course, we ask the people for their opinion. So we ask people to fill out a questionnaire with their experience, but we also collect anonymous statistics about these questions, which were visited for how long and so on. So that's the current state of the JusticeBot interface. So the idea is really to show users information to support them in their decision making. And we hope that this will have some positive effects. We'll discuss later as well, but ideally this would increase legal harmony since people would be able to take this information, to settle their cases. So that could increase social peace if more people are able to deal with their conflicts like this. And it could potentially take cases that aren't necessarily that complex out of the court system and give people the tools to solve these themselves. Of course, as I mentioned, this could also have implications for the rule of law. If courts might not be always able to deal with these conflicts, tools like this could potentially provide people with the possibility of solving conflicts on their own in accordance with the law. So that's the JusticeBot project. So next we want to discuss some potential impacts that could have. Of course, it's always important to keep in mind what the potential consequence of such a tool could be. So I wanted to give the word to Mark here to discuss some of the potential impacts.
Thank you very much, Hannes. So hi, everyone. My name is Mark Likhten. I'm a lawyer working at the Cyberjustice Lab. And I wanted to add a few comments for the benefits of the discussion on nudges today, since I have been working on this project with Hannes, and maybe bring to your attention some of the elements we've seen while reviewing the platform for the discussion. And since we're looking at a pilot project, this discussion that we're having today is very valuable to us. It's very interesting. So I would start by saying that what we're trying to do with the JusticeBot here is it's relatively new. since we're trying to bring case law to the general public, while traditional case law has been of interest maybe mainly to legal professionals. So this in itself could be seen as an advancement for access to justice, especially in Quebec, where case law is not the primary source of law, and it helps people understand certain legal concepts or notions, as Hannes said. However, this poses a number of difficulties and opens the door to a number of nudges in the platform. One of the most widely recognized principles to have a good legal platform is to avoid legal jargon and use simple text. However, when we're working with the Justice Bot and with case law, as we do, not only do we choose the decisions, but we also have to summarize them in 2 to 3 sentences, in addition to the simplification of the wording, which is often in the decision itself very legal and sometimes very technical. So this obviously makes us choose what is the most relevant part of a given decision, but it can certainly influence the end user in the way they use our platform, in their understanding of their situation, and their further actions. So I think it's a good example here of one access to justice imperative of simplification of text influencing another, which is nudging in this case. So in order to somehow compensate this, and which brings us to the second point, accessibility of information. So in order to compensate this, we tried not only to give the reference of the decisions for the parties to go and look for them when needed, but we also made them clickable, as Hannes showed. So they're readily available, which we hope will prompt the users to go and read them. And so this nudge towards reading the full decisions, and actually all the nudges, they're also influenced by the device through which we access a platform. And the responsiveness of the design is very important for many aspects, but it also has an influence on the use people will make of the platform and on these nudges. And I think it would be very interesting to monitor in the Justice Bot whether people go and read the decisions more often on a computer than when they're accessing the platform through a mobile device, for example, a cell phone. So that would be for this. And also, I would like to add a few comments on this distinction between legal advice and legal information, which we've touched upon just in the discussion before the break. Maybe for the benefit of everyone, since we have participants all over the world. In Quebec here, legal advice and legal consultation is a reserved act for lawyers and notaries, and anyone else doing that exposes himself to sanctions. So, and as Tom mentioned earlier, this is a fine line to navigate. We have to stick to legal information and not fall in this realm of legal advice. So this obviously prompted some decisions while we were developing the platform. And I think it's a good example of legal requirements creating nudges. So the information we give, the way we present it, the results at the end, that all must remain general legal information. And because of this, we will sometimes limit the extent of what we have provided the user intentionally because of this legal obligation. So we will be directing user toward more general legal information than legal advice, which we could have done maybe if it was allowed in some context. But, you know, just as an example, at the end results page Hannes showed you, there's an option that you might contact the tribunal for more information, for example. But we cannot say, given your answers, you absolutely have a good case and you should file right away. Yeah, so that were my 2 cents. I'll let Hannes finish and hopefully jump in the conversation after that.
Thank you, Mark. So finally, I want to talk a bit about the impact on the decisions that individuals take. So of course, the idea of the Justice Bot is to provide information, but I think no matter what this platform will do, since people will use it and what they know will change because of it, it will have some impact potentially on the decision making of these people. So I think it would be important to think about this and to remain aware of what the potential consequences of people using the tool could be. Of course, there's many possible positive consequences of the use of such a tool. I mean, this tool might give people access to information that they wouldn't have otherwise. They might not have the possibility to contact a lawyer, and using this tool would just give them more information that they otherwise wouldn't have had. And this could lead them to being better informed. That is, they would have more information to make the decision on, and they could make decisions that would be better for them. It could also lead to people using this information to settle. As I mentioned, this I think would be a huge, a very interesting thing if people took this information, went to the counterparty and said, look, this is what is potentially going to happen, so perhaps you should settle this somewhere in this area rather than going to court. So that is something that could be very positive, but as Sylvain mentioned before, we also have to be aware of who this benefits. And that's something I'll get back to as well. There's also some potential negative consequences, I think. One potential negative consequence is that people might not really understand what exactly the system does and might put too much reliance into the information presented. So this, of course, gives us a big power, but also a big responsibility to decide what people should see, which case they should see, and which order the information should be presented. Of course, when going to real court, there is always going to be stuff that we can't provide information about in the justice, but that will probably be important, such as the evidence that's required to prove a side. And in the end, the judge is likely to make case-by-case assessment. So I think one thing that's very important here is to be fully transparent, to say what we're doing and the limitations of what we're doing. And that's something we try to put in as many places as possible, to put a disclaimer. This is based on previous cases, it might not apply to your case, and so on. But in the end, what we're doing, I see not as much as kind of analyzing the situation, but more giving the user the tools to do that themselves. The system isn't really doing any interpretation in the traditional sense, but rather they're showing the user court cases that allow them themselves to do that interpretation. Also, I mean, the data we have to deal with is a lot of case law. So that might give the impression to the user that going to the court is the only possibility. While in the real world, settling is, of course, an option. So potentially a system could result in more cases going to court, or people realizing they might have a right that they wouldn't have otherwise have realized in going to court based on that. So that's also something to remain aware of, that this possible interaction also exists. Of course, we try to provide the information of all the possibilities to balance this. So to conclude, what we're building here is a tool to present relevant information to parties of potential conflicts. It tries to leave the interpretation of the data up to the individual. So I think it's an example of kind of augmented intelligence, where we give relevant tools to the user for themselves be able to come to a decision. But it's, of course, very important to evaluate the effects of such a tool in the world. And we discussed this before, but this is, of course, not simple at all. And there's some questions that have to be answered with regards to this evaluation. First, of course, what are desirable outcomes? What would we like to achieve with this case? And desirable outcomes for who? Who should be the target beneficiary or multiple? Who should be the stakeholders? Is it the court system, the taxpayer, the parties of the process, so on? Then another question is, how can we measure these outcomes? What precise metrics can we tie to these outcomes? And I think another very important question is, who has the right to make these decisions, to determine which outcomes are desirable and how to achieve them? So that is it for us. Thank you so much for listening, and we're really looking forward to the discussion now. Thank you.
Thank you, gentlemen. And my apologies, Mark. I did not know you were going to take part. So it's not because I was ignoring you at first, simply because I was unaware. And so our third and final presentation will be given by Professor Ken Satoh. And at the beginning, I made a point of thanking Richard for getting up so early. I need to personally thank Professor Satoh for staying up so late, because if my math is correct, it's roughly 1 a.m. In Japan. And so thank you so much for staying up this late to present your platform to us. So Professor Satoh, for those of you who aren't familiar with his work, is a professor at the National Institute of Informatics and at Sokendai, which is the Graduate University of Advanced Studies. And as I mentioned at the very beginning, he'll be presenting his system for arranging issues in civil litigation. So Professor Satoh, the floor is yours, and Valentin, please give him control of the screen.
Thank you very much for the kind introduction and giving me a chance to present my paper, to my work. Can you hear me? Okay. So I'd like to talk about the interactive system for arranging issues based on ProReg. And this is joint work with Takahashi and Kawasaki. The outline of this talk is as follows: that I would like to talk about some background and then the ProReg, and then I give an extension of ProReg to arrange issues, and I give demonstration. So background is that in Japan, we have the procedure of arranging issues in civil litigation, where we clarify which facts are in dispute and what kind of evidence of actions should be made. And in the beginning of, unfortunately, the Japanese court system is quite late for the IT technology. In the beginning of last year, the Japanese court decided to use Microsoft Teams for arranging issues, and they said that they would start the procedure from May 2020. And so before that, there is no such a kind of online system to arranging issues. Well, precisely speaking, they use some kind of telephone-based interaction, online interaction, but that's all. But however, the usage of Microsoft Teams is just to replace face-to-face procedure by the one in distributed environment. So they didn't apply IT technology in full use. So I would like to make my ProReg system to use for this arranging issues. So we have been developed ProReg since 2009 to simulate reasoning by judges in litigation. And it is a support for judgment reasoning in civil litigation. And it consists of 2,500 rules for civil code and Supreme Court case law. And the function of ProReg is, the original function of ProReg is to simulate judgment after finishing all the facts presented. But in this presentation, we extend ProReg into an interactive system called IntProReg for arranging issues. However, it is just an experimental system, and is not commercially available like the other systems. And basically, I'd like, and the implementation is quite straightforward, and there are not so much nudges, but I would like to have feedback from you. How can I introduce some nudges to enhance this system? And also, Japan is rule-based country, which is different from case-based country. So basically, we use rules to make a judgment. So, for example, this is a kind of claims in civil litigation. So Alice claims I don't do a sales of water purifiers on January 15th, 2020, when I visited Bob's home and explained about the water purifier. And there are many claims from the Alice, and it is quite complicated. But actually, so in this Alice's claim, she would like to have money from the Bob, and it is not so clear that what kind of facts should be asserted to get this legal effect of getting money. And the Bob also makes some counter argument about the claims, and somehow it is quite contradictory. And so there are some issues to be decided by judges, and we would like to find out which kind of necessary facts should be determined and so on. So it is necessary to extract the legal facts from the above claims to form an appropriate argument in the court. And if any side doesn't make a claim in a legally correct manner, the side will lose the case in the trial. So it is very important to extract the necessary, sufficient and necessary concrete facts. However, the above claims contain various facts, and it is not clear which of them should be selected, and the interprolec can choose requirement facts automatically by reasoning about proleg rules. So a proleg rule consists of general rules and exceptions. And the general rule is that H if B1 to Bn, meaning if B1 to Bn are true, H is true in general, and there is an exception. That the exception HE means that even if H is satisfied by these conditions, if E is true, then the H is not satisfied. And E is also have some conditions like this general rule and so on. And for fact base consists of truth value of basic facts of the form fact P. And we can visualize judgment reasoning by a proleg block diagram like this. And so firstly, the conclusion, and there is a reason of claim 1 and claim 2. And then there is some counter arguments. And then there is counter argument, and so on. So that this is a kind of dispute tree about the argument in the court. So in proleg, we encode Japanese Civil Code and Supreme Court cases. It rules into proleg rule in proleg. And so this is the same as the proleg system, but instead of giving facts at once to simulate judge's reasoning, into proleg we will ask necessary facts as follows. So plaintiff is asked to choose a desired fact effect in the litigation, and the proleg calculates possible justification for the desired effect using encoded rules of civil code and case rules. And the plaintiff is asked to choose justifications. And then in proleg calculates necessary abstract facts for the choose justification, and the plaintiff is asked to fill in the correct facts. And the proleg block diagram based on these facts from the plaintiff displayed and sent to the defendant. So this is just the reason of claims. And then the interproleg calculates possible counter arguments for the kind of justification, and defendant is asked to choose counter arguments. And the interproleg calculates necessary abstract facts for the chosen counter arguments, and the defendant is asked whether the defendant admits concrete facts given by plaintiff or not. If not, it becomes issue, which judge should determine the truth value and the proleg block diagram based on the concrete facts previously given by plaintiff and given by defendant are sent to plaintiff like this, so that the counter argument is added. And gradually we make this dispute tree by asking either side to make an argument. And so basically that this part is the same but this is counter argument case and so on. So we iterate this process until no further arguments given by either party, and then the issue can be found in the dispute tree like this. So I would like to make demonstration here. Wait a minute. This maybe not this one. Can you see the product menu? So
Yes, we can.
so firstly, the plaintiff choose the justification of the claims. So I want to request money payment. So then there is some justification to get money. So requesting money based on purchase contract or based on service contract, and request money based on loan contract and so on. And then we choose this. Then the product calculate which fact is needed to establish requesting money based on purchase contract. And so this, in this case, a purchase contract agreement is a necessary fact to establish this one. And then we add the concrete fact here. So seller is Alice and buyer is both, and contract is C1. And then this part is Q is the question. So we need to arrange this fact. Then I changed Q into O. And then we can simulate judge's reasoning based on this fact like this. So oops. Simulate the reasoning. Then before that, this is the current conclusion, and the previously it is U, undefined, but then it becomes O, which is established. Then, then we need to calculate the counter argument. So this tree is sent to defendant. Then the product defendant asks into product to calculate the counter argument, and the box is changed into green, which has a counter argument. So there are various counter arguments based on the civil code or case rule. And then the defendant is choosing some counter argument. In this, I choose this rescinding of contract due to duress, and then we need to change the concrete facts. So we need contract by Venus or something like that. So we should put the duress action, and it becomes O. And this part is also O. And this part is also O. Then we apply this fact. Then the tree becomes expanded of this counter argument. And we don't choose this another counter argument, so that if we compute the judgment, then the but this sorry, that this doesn't work currently, so I'm not quite sure that no. I'm sorry that I did it again, but I'm not quite sure that I can do it. Okay, so A, B, and O. Then the date. And then I choose this part, and then open. And I should put O. This part is also O. And upright. Then it should work. But anyway, in this case, actually that this part is asked by plaintiff. So if we would like to make this part issue, then we change this part, this O into U, then it becomes issue. And if this counter argument is successful, then the plaintiff will ask whether these facts are admitted by a plaintiff or not. And if it becomes U, then it becomes issues as well. I'm trying to make this, I hope it. Oh, yes. So this time it works. So this part is a counter argument. So see, although this condition is true, the counter argument true, therefore that the conclusion becomes false. The X is false. So that currently this counter argument is successful, and then we compute the another counter argument, but there is no counter argument there. So only action which can plaintiff do is to change it into issues so that the menace is not exists, and so on. And then I can calculate this. So in this case, this part is U, therefore these parts are issues, and then this part becomes U, therefore that the conclusion becomes undefined. So if this part is decided, then the judge will do the same thing, so that the either winning, the plaintiff winning or defendant winning. But if it is U, then there is some issues to be determined by judges, and the issue can be found by this node. Okay, so I finish my talk. So this is an extension project to arrange issues. Attorneys can prevent missing claims by using this system for checking. And the layperson could make correct legal claims. So that from the very complicated stories, by using this product into product, the necessary fact can be identified. A future bug is that we just made this system, so we need evaluation of the system by lay people or lawyers. And also, we would like to have some automatic information execution from claims written in a natural language. That's all. Thank you very much.
Well, thank you so much, Professor Satoh, for presenting this extremely interesting and hopefully promising project.